Welcome back to Rethink Your Legacy. We're bringing you one of our favorite episodes from this year. Hope you enjoy it.
Uno, dos, 1, 2, 3, 4.
Well, good morning, everybody. Welcome back to Rethink Your Legacy. Good morning. This is Francisco Servent. I am your attorney and problem solver at law, hailing all the way from Chandler, from Keystone Law Firm, where we help families create a new legacy. I truly believe that, it's our job every day to do that. And one little piece of that puzzle, well, maybe not so little, but is your estate plan. At our firm at Keystone, I have we have this saying going around that it's that your estate plan is your last chance to make a difference to the people you love. And while I truly believe that, I also believe we shouldn't wait for that moment to make a difference in their lives. We should do this every day. So that's why this show is here. It's to help us think about these things right now, right? While we still have a chance, because tomorrow is not guaranteed. And yeah, we have to do these things now. And I believe that with all my heart that it's our obligation, really. But not everyone steps up to it. I believe it is a choice each of us has to make to decide to make a difference. And so that's why we're here, I'm excited to be here today specifically because we had a couple things happen in the office that are sad stories, and I hope it gets all of us a little bit more motivated to understand the things that are left behind when we're gone. But before we get to that, I thought I've got a couple things I just want to highlight from this week. If you haven't heard, I think one of the biggest pieces of local news this week is the announcement from Intel that they're going to expand their facilities here in Arizona, making a $20 billion investment into our local economy. I just think that is freaking amazing. Isn't that just wonderful? It's, $20 billion. They're estimating like 3,000 construction jobs during the construction, and then thousands and thousands of jobs either directly within the facility or ancillary support jobs created from this expansion. And I love our state. I think we have so much good to offer companies like this for their long-term stability, long-term success. It's just a really cool thing. So that's my first big piece of news that I want to highlight. Second big, right? Everyone gets a vaccine, 16 and over. Governor Ducey lifted any other limitations, so go grab your vaccine if you haven't gotten it and that's what you want to do. So bam, right? Vaccines for everyone. Well, okay. So that's the regular news. Well, here's some things that aren't in the news because they don't get publicized. These are usually private affairs. We had two just insane, stupid, frustrating, ridiculous things happen to clients of ours this week. Now, these were people who didn't necessarily have everything in order correctly. And so we get calls, I want to set up my will, I want to set up my trust, I want to update my trust, I want to, do I need a will, do I need a trust? We get those kind of phone calls, and that's great. We're happy to help. We've been doing that for years. We've helped thousands of families. If you have that question, give us a call. Happy to do it. Your first call, that first appointment is free. There's no charge for that. You can just call, jot this number down, 480-750-7788, and that'll get you right to someone on our team. Well, it's Sunday morning. It'll get you right to someone on our team. They'll call you back Monday morning. If that's you, great. We also get calls from people who had somebody pass away, and they weren't necessarily a client of ours. We maybe have never, interacted with that family before, and they're just running into some problems. A bank is telling them something. The financial advisor says you can't do it. A real estate agent, a title company, they want to sell the house. The title company's like, sorry, you can't. something is wrong, and somebody is telling them you need probate, you need guardianship, you need letters of appointment. These are some of the trigger words that they might read off to you, and then they call us. Well, this week, we had just these two crazy stories happen. So the first one was somebody's at a bank, okay, and they're trying to take care of their mom's affairs, or they're trying to take care of their mom. Their mom's alive, but they're trying to take care of her. And she's acting as the power of attorney for mom, and she's got that legal document, that one that says, I designate my daughter as my power of attorney. Cool. This particular document, we've reviewed it, we've analyzed it, it's valid. Just black and white. This is not a gray area of the law. It is valid. 100% valid. Mom's got a bank account. It's only got her name on it. So the only way to get to that is either mom walks into the bank and, transfers the money around or signs a check or whatever. But mom's incapacitated, so she can't do that. So then the power of attorney is there to be able to do that. That's what that document is for. So daughter goes into the bank. And I'm not going to name names. You guys know this bank. And she goes in, she gives them the power of attorney and a letter from the doctor saying mom's incapacitated. And the bank reviews it. They look it over. They kind of analyze the legalese that's in there because they're qualified to do that apparently. And, they have to do that, right? They have to make sure, they have to do their due diligence, right? So they look at it, they evaluate it. They see a clause in there that exists in any good power of attorney document. Any good power of attorney document would have this clause. It says, if I... I can't remember the exact clause, but it says... So this was a power of attorney that was created while she was married, okay? So, and her husband had since passed away. So it said in there, this power of attorney with respect to my spouse shall be, my spouse will be deemed to have, we will pass over him, we will skip him with all powers. He will have no powers if my spouse and I are divorced or the marriage is annulled. And so, okay, so it's kind of, if you create a power of attorney with a spouse and then you later get divorced, you want that power of attorney to say, no, you don't have any power. So that's what this document said. Any good power of attorney would have that. Well, the bank, they read that and they said to the daughter, well, you know what? We are not allowed to inquire about her marital status. And since this power of attorney is contingent on her marital status, we can't do anything with it because we don't know her marital status. Wait. Let me make sure I said that correctly. Here's how the bank said it. This power of attorney says that it's revoked if she's divorced. We're not allowed to ask you if she's divorced. And because this power of attorney document is contingent on whether or not she is divorced, and we don't know that fact, we can't honor it. Holy crap, are you kidding me? Yes, that is exactly what they told her. Can you imagine that? The insanity of that logic? So some branch manager out there needs to pull their head out of their you-know-what. So what'd we tell them? Go to a different branch, right? Try a different branch, because that's insane. The other crazy thing that happened is someone with a safe deposit box. I am not a fan of safe deposit boxes. Sorry, banks. I just am not. I've had too many crazy things happen with bank safe deposit boxes. Yeah, not a fan. And another story that confirms my suspicions, which is that the dad passed away with a safe deposit box here in Arizona. I think it's the daughter, is the named executor, has the authority, legal authority, to administer all of his affairs, but lives in Washington. Okay, doesn't want to fly down here just to open safe deposit box and see it's nothing. So she delegates that power legally to her lawyers. Lawyers go to the bank and the bank says, no, we can't let the lawyers go in there. We're going to empty the contents of the safe deposit box and ship them up to you, period. Bam, there you go. Crazy. Guys, this is the problem with not having your trust funded, and that's what we're going to focus on today, is what do you need to do to get everything owned by your trust? I'm going to give you a 6-page report on it. Write this website down. It's free. I want you to have this while we go through it. It's the same one every week, radio.keystonelawfirm.com. radio.keystonelawfirm.com. Go over there, enter your name and email, get this 6-page report because I'm going to go through it today with you. I want you to get your trusts funded. If you don't have a trust, give me a call, shoot us a text. Let's figure out what it needs to be, what needs to happen to get it done. It's 480-750-7788. Don't make this more complicated than it is. All right, we'll see you back here in just a minute. Welcome back to Rethink Your Legacy. We're bringing you one of our favorite episodes from this year. Hope you enjoy it. Welcome back, everybody. Welcome back to Rethink Your Legacy. I want to help, for those of you that have a living trust, you've got this thing done and it's now collecting dust properly on a bookshelf or in a file somewhere. You're going to have to go back and listen to one of my shows where I go deeply into the topic of how often you need to update these things, because that's just one of the worst, and it's one of the simplest things to fix. One of the worst or most common problems with living trust is them getting out of date. But if you've got one, I want you to know and make sure you know how to make how everything is funded, right? And funded, here's what that means, okay, before I get into any of the specific instructions. Funded means that your house, the title on your house, on the recorders, at the recorder's office says for example, Francisco and Nicole Servant Living Trust. That's what it says. It doesn't say Francisco and Nicole Servant Community Property with Right of Survivorship. No. It says Francisco and Nicole Servant Trust. That's what I mean. Or your bank account, your checking, your savings, your investment accounts. They say, Francisco Servant Trust, dated whatever. Or you and your spouse trust, whatever it is, it needs to say trust. That's what I mean when I say funded, or even like with life insurance that it says trust on the beneficiary. What I want to go through today is give you some specific guidance on the specific types of accounts that you have to deal with, and maybe some of the tricks of the trade that we've had to figure out helping people go through this. The problems we've run into, the mistakes that often get made, thought it was like this and it wasn't like that and made a big mistake. And so give you the tools to do that. It's all organized in something we have that we give to our clients. Normally we only give this to clients, but I want to give this to you guys. It's a 6-page instructions, and this is maybe the meatiest thing I've tried to give everybody here on this show. Most of what I give you guys is, got pretty graphics and really simple, really concise, very to the point. This is pretty deep. It's pretty, and I'm going to even use this word technical. I don't want to scare you away from getting it. I'm encouraging you to get it as a tool. We give this to clients, okay? This is what we give to clients so that they can get this done. And I want to give it to you. I want you guys to get this. That's what the website is set up for today. So go over there, radio.keystonelawfirm.com, and enter your name and email. The system will send it to you immediately, and you can have a copy of this. Store it. What's nice about email, right? If it gets sent to your email, it stays there forever. So if you need it at any point in the future, you've got it. So I recommend you go there right now and get it so we can go through this together. radio.keystonelawfirm.com, and you'll see a picture of my awesome family there as well. You'll see the family, and enter your name and email. The system will send it to you. Grab it. Save it for later, or go through it with me now, even better, right? We're not going to get through all of it, but let's get through as much of it as we can. Okay. The first thing, it's funny, we create these tools for our clients, and I try to get back at least once a year to review them and update them. Some things don't need a review even annually, but the first sentence of this one I just love. We cannot overemphasize the importance of having a fully funded, revocable trust. Oh my gosh, I can't overemphasize that sentence. There are a lot of estate planning lawyers, estate planning professionals out there that will create your trust. A couple of my employees came from other firms that did that, and we go through training with them and say, here's how we do this, here's how we do that. And one of them sticks out in my mind. She said, I probably witnessed hundreds, maybe thousands of trusts being signed at this firm that I used to be at. They never, ever even mentioned trust funding. I don't even know what it was until I came here. And I'm just like, holy crap. And this is standard for my industry. The standard in the industry is to give you a nice, cheap trust and tell you nothing about this big project called funding. It has to be done, or else your estate, your house, your bank accounts end up in probate, end up frozen, end up locked into the court system. Like a number of years ago, one of my early clients was married and needed to go get access to their nest egg because husband had dementia. It had gotten to the point where she needed to take over all the finances. She goes to the investment advisor and says, I need to become a signer on the account. Here's the will, here's the trust, here's the power of attorney. These are all documents they had prepared years earlier. And he reviews them, goes to his compliance department, comes back and says, no, your accounts were never funded to your trust. She's like, well, what does that even mean? I don't know what that means. And he said, well, these accounts are, some are in your name. You obviously have access to those. Some are in you and your husband's name. It's joint. You have access to those. But some are just in your husband's name. And he is the only one who can sign on those. And she said, well, yeah, but we've got all these legal documents. And his compliance department's like, well, your power of attorney is way too old, so they're not going to recognize that. The trust doesn't own these accounts, so it doesn't help you. And so she's literally stuck. And of course, where's most of their money? It's in the accounts that are in his name alone. So the financial advisor is like going through their policy book, and he's like, how can she get access to this? And it says the next step, the last and final resort, is that she gets an order from the court that appoints her as the conservator. And that's how they got referred to me, is we had to help her go through that process. That process is a nightmare, guys. It's called a living probate, or I call it a living probate. They have spent hundreds of thousands of dollars going through that process. We unfortunately get those calls every single week. Somebody's stuck with that, and the money's frozen. And if they don't get a court order to go get it, court permission, then they can't get it. So, yeah, I can't overemphasize the importance of funding everything to your trust, okay? Now, even though we at our firm do the funding for our clients, so you come to us, I'm going to tell you, you need to let us do your funding, okay? Some of our clients are pretty savvy, professionals who are accustomed to dealing with financial matters. And in those cases, we will let you give it a try on your own, but we will hammer it in your head that it has to be done. We'll give you tools like this one, which you can go get right now from me, from this show. Go to radio.keystonelawfirm.com and grab our revocable trust funding instructions. This is the tool to making it easy for yourself and your family, and to staying out of trouble with your estate plan. Even if you got your trust done somewhere else, grab this, get it done, and know that your estate plan is protected. The first type of thing I want to make sure you know with respect to trust funding is that your revocable living trust it continues to use your social security number. It does not use a new tax ID number. If somebody got you a new tax ID number for your revocable living trust, they did it wrong. Do not use that tax ID number. Tell the IRS you don't need it. You just don't need it. It uses your social security number. That is the first and most important thing that I want you to know about funding your trust. The second thing is that you're not going to use your whole long legal trust document to do all this funding with your bank and investment and whatever. You're going to use a short 2-page certificate of trust. It's just a little quick legal document, 2 pages, that says I have a trust, it exists, and here's the basic details that the bank needs to know. Period. That's it. 2 pages, certificate of trust. Okay? All right. Go to radio.keystonelawfirm.com. Get a copy of this. Save it for later. Or let's go over it now. We're chewing through it. We're already through a page and a half, and let's protect your family. Okay, let's get that done. The other thing that I want to just mention again, because we keep having people ask questions about it, is our new master class kit. We launched this at the beginning of the year. It's been phenomenal. People are getting their plans done. We decided last year to create a totally DIY service. Yeah, do it yourself. Completely simple. After helping thousands of families do this, we figured out how to make it super, super simple. I think this is better than anything else out there that's a DIY service. And it's only $347 for the whole living trust, power of attorneys, healthcare directives, everything. And if you want a $50 discount, then send an email to radio@keystonelawfirm.com or send a text to 480-750-7788, and we'll get you a $50 off promo code for that masterclass kit. All right, we'll see you back here in a minute to pick up on our specific assets and types of accounts and how to make them owned by your trust. Welcome back to Rethink Your Legacy. We're bringing you one of our favorite episodes from this year. Hope you enjoy it. Welcome back. Good morning, everybody. Welcome back to Rethink Your Legacy. And if you're just joining us, my name is Francisco Servent. I am an estate planning and asset protection attorney in Chandler. I'm the owner of Keystone Law Firm. We are a boutique estate planning firm, and we help people create a new legacy. The topic for today stems from some insanity happening in the office. I guess not in the office, but just from people who are calling us for help. And we just had a couple of crazy stories of things that banks are doing when your stuff is not owned by your trust and how they react to that. It's just not predictable when it's not in the trust. And the only thing that I've found to be predictable or consistent enough to give as a recommendation is to have these things owned by your trust, period. So far, when it's owned by a trust, I haven't run into any of these problems before. It's owned by a trust, it's like boom, boom, boom. It happens kind of how we think it should happen. The common sense idea. Our laws and our banks do not operate on common sense. So there you go. That's my word of wisdom for the day. Now today we're giving away what I'm giving, and I want to put in your email inbox, what I want to give you, what I want you to store for your family, for yourself, is our trust funding instructions. These are the actual instructions we give to our own clients. So normally you only get this if you've paid us, if you've hired us, and I just this week talking with my team, I'm like, we got to get more people this information. So there you go. You're going to get your hands on something that we only give away to clients. So go to radio.keystonelawfirm.com, enter your name, your email, and our website will send it right away to you. Grab it in your email inbox there, and let's go through it. We're already through a page and a half of it. What I want to pick up on is what the recommendation, this is a question I get all the time. Do I need to put my bank account into the trust? Shouldn't I just put my son, my daughter on the account joint with me? Or shouldn't I just name them as beneficiary, right? As a POD, pay on death beneficiary. Shouldn't I just do that? Isn't that good enough? So yes and no. Yes, those can take care of some things, but they also don't take care of some other things, and then there's these unintended consequences. With the bank account itself, or with anything, if you add somebody to the title of it, like, say you put your daughter on the bank account, or you put whatever, right? As soon as you do that, you then make that thing essentially an asset that their creditors can come after. So if they got into a car accident, they could very rightfully come after and seize that bank account. If they are married and they got into a divorce and got into an ugly battle over money, they could very rightfully cause a big problem for you and claim that is part of the marital estate to be divided. And so that's a big downside of adding somebody to your bank accounts. The other big one is a tax problem, which can really screw up your gains, your capital gains taxes. There are lots of good tax exemptions when you own things yourself and you use those personal exemptions. When you add somebody else to the title, especially someone who's not your spouse, your legally married spouse, you can lose a lot of those exemptions. So that's a big unintended consequence, is wasting a bunch of tax dollars. The other side is, well, I'll just add them as POD. Yeah, that works. That does transfer things immediately on death if, number one, they survive you, which it just happens way too often that doesn't happen. And then second, that you have no time, you have no minutes where you are incapacitated and they need to use that account while you're alive. Because if they need to use that account to pay your bills and such, and you're incapacitated and they're only a beneficiary at death, then nothing changes while you're alive and the account becomes frozen. So all of these things are avoided, all of these problems are avoided, and then you get all the good stuff. You get to have control while you're alive. It's not in their name at all. If something happens to you, you become incapacitated, the trust lets them have control while you're alive. And then at death, whoever you've named as beneficiaries are there, plus you have the backup beneficiaries in your trust. All of those things are taken care of if you fund your account, your checking account, your savings account to your trust. That's, yes, truly my recommendation. Even your basic day-to-day, the one you drain after payday, it's like payday goes up, then it just works its way down until next payday, then it goes up. That's fine. Even that one should go into the name of your trust. And if you don't have a trust yet, I recommend you get one. I've started recommending living trust for almost everybody. It's very, very rare that I say, oh yeah, a will actually will be good for you. I just don't make that recommendation very often. So anyway, if you're ready to do that, you can do that. We've got the super simple do-it-yourself version that I mentioned just a minute ago. Our masterclass kit, it's $347. If you want that and you want the promo code for that to get $50 off, send an email in, radio@keystonelawfirm.com to say I'm interested in the masterclass, or you can text it to 480-750-7788. Say, can I get info on the masterclass? That's the super simple, the cheapest way to do it. I think that masterclass DIY kit is one of the, if not the best way to get this done using a do-it-yourself service. We've been able to create that because we've done thousands of families plans where in our very white glove concierge service, that's what we're really known for, is that very interactive, lots of counseling, lots of education, lots of training, where you don't have to figure things out. You just get to say, here's what I want. tell me when I need to make a decision, and we say, okay, it's A or B, here's the pros and cons of each, which one do you feel is better? And you say A, and we counsel you through every single step of the way. Obviously, those plans start in the $3 to $5 to $8,000 range. If you want to learn more information about that, you can schedule a free appointment and be happy to talk to you about what those options are. Just call our office, 480-750-7788, and ask for your free appointment to be scheduled. And then you'll have a living trust, and then you'll need to fund it, your checking account, into that trust name. Yes, I do. I absolutely recommend it. Look, you're not paying me for this advice. I'm just telling it to you straight. Okay, this is my absolute recommendation. The second thing that I want to hit on before we run up to the break is your retirement accounts. There are lots of different retirement accounts. I don't have time to go through all of them. But the two I want to hit on, I think these are the most common, are 401ks and IRAs. These are accounts that you put money into. You don't pay taxes on the money that you put in. When you get to retirement age, you start taking withdrawals. You do. You pay tax on the money when it comes out at that time. So these accounts, as simple as they might seem to you, there are an insane amount of tax laws like behind them and that allow them to work this way. So I do not recommend ever naming your trust as the beneficiary of your retirement accounts. Period. I do not. If you have some beneficiaries that need protection, they should not be getting these lump sums of money. There's a different type of trust for that purpose. It's called a standalone retirement trust. And if you haven't been advised about that or what that option is, that's something I've done shows on. You can call and get information on it. You can call and set up an appointment. But that's what you have to use, a standalone retirement trust. It's very critical that you have that so you don't blow up the taxes and ruin all these good tax strategies that you have built into it, okay? So on your retirement plans, if you don't have a standalone retirement trust, I recommend you just name your beneficiaries directly. Either your individuals, your individual people, or charities, whoever it is, just name them right on the account beneficiary form, okay? And that's, so we're coming up on the break, and I just want to remind you where to get this tool I'm giving away, this Revocable Living Trust Funding Instructions. My gift to you today, it's at radio.keystonelawfirm.com. On that website, enter your name and email, and the website sends it immediately to you. It's got all these details in there, so you can show it to someone and say, well, they said this. See, it's written right here. And I'm happy to give that to you. I want you to put that in your toolkit. All right, so we'll be back after the break where I want to pick up and talk about real estate and a twist that I recommend for life insurance. All right, we'll see you here in just a minute. Welcome back to Rethink Your Legacy. We're bringing you one of our favorite episodes from this year. Hope you enjoy it. Welcome back, everybody. It's our last few minutes together, and I want to share with you my little trick on life insurance funding and how to make sure it's owned by your trust properly, and then a couple quick tips on real estate. We did a whole show on real estate a few weeks ago, so I'm not gonna go too deep into that one. If you want today's giveaway, my little, it's really freaking amazing. It's 6 pages of trust funding instructions. If you have a trust, you're thinking about getting a trust, or you need a trust, I would put this thing in your toolkit. I would put it in there for your family so you can do what you need to do, because you may not get this advice depending on where you go to get your trust from. So go to radio.keystonelawfirm.com, enter your name and email, and my website will send it right to you. You will get it immediately. So, look at it immediately, read it later, whatever. Just don't not get it. Get it. Like that's the key. Like I said earlier, we only have ever given this to clients who pay us for their trust, right? Who we create their trust for, but then we give this to them. We had a couple crazy things happen this week, and I'm like, nope, we're giving this away. So here it is. It's yours. Okay. My twist on life insurance. If you have a living trust, so again, I start with the assumption I believe every family needs a living trust. Forget the will. That's from like the 1800s. Great back then. Nowadays in Arizona with the current laws, get a trust. You get a trust. What do you do with your life insurance? Think about life insurance, right? That pays when you die. And then some life insurance has some value while we're alive, like that cash value buildup, right? Okay, break it into two parts. Pays out when I die. Okay, normally they just say put in your spouse, put in your kids as beneficiary. Okay, I like to do something a little bit different on that. I say name your spouse as the primary beneficiary within your trust and then have everything fund into the trust. So have the life insurance beneficiary be your trust. That way you die, the check goes to your trust, which is controlled by your spouse. Great. You've also got the backup beneficiaries under your trust, your kids, your other beneficiaries, whoever they are. So it automatically captures all those scenarios, and you don't have to wonder what's going to happen. The second thing on life insurance, even if it's just a term life policy, I don't care. If it has no cash value, if it has cash value, then absolutely for sure, you should make that policy owned by your trust today. Make it owned by your trust today, because if you become incapacitated and something needs to be done with the policy, extend it, make some election, sign and fill out some form to keep it going. And if you're incapacitated and you can't do that, you want somebody to be able to do that, because that policy is going to be exceptionally important. If you're incapacitated, that probably means, there's a risk that you will die soon. So I recommend you own the policies in your trust, period. Okay? All right. And then let's touch on real estate. Real estate, there's lots of varieties of ways that you could own real estate. My recommendation for your primary home is that you have your trust own it. If you have a mortgage on it, then at least have a beneficiary deed that puts it in your trust after death. If you own it outright with no mortgage, then you can create something. We use a special warranty deed with some special language in it to make it owned by your trust right now. And then you can sell it if you need to, no problems. Either way, with a mortgage, without a mortgage, if it's in your trust, you won't run into problems if you become incapacitated and your spouse needs to sell it. If you're married, you guys are on the title jointly and one of you is incapacitated, the other one can't sign for you unless you have it in your trust. And then same thing after death, of course. If you or both of you pass away, whoever you've designated will be able to sell it, transfer it, deed it to whoever you designate. And so that's where I land on real estate. Now, if you have rental properties, if you have business real estate, it's different. I'll recommend a living LLC, some type of asset protection, some type of business entity structure. But that's a topic for another day. Maybe I need to schedule that one for the show sometime. All right, so that's it. Go grab this tool and then save it, tuck it in there, or get to work. Get to work on funding your trust. Go to radio.keystonelawfirm.com, enter your name and email, and you'll get it right away tucked into your inbox. Okay, before we wrap up, I've got a couple more minutes that I want to just kind of have a reminder for a few of you, because we get questions on this, and hopefully I can answer some of these for you before you ever have to call anybody and figure this out. The first question I know a bunch of you are wondering is, how much is this going to cost? If I need to get my trust done, how much is this going to cost? Look, our firm last year during the pandemic had like a tidal wave of people asking that question. And, as a boutique estate planning firm, we've done this for 14, 15 years now. We've been, at a higher price point where our services were $3,000, $5,000, $8,000. And a lot of families were just like, you know what, that's not what we want to spend. I get it. It's worth it. I understand you get what you pay for, but it's just not in the budget. And so, hearing that over and 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 over last year, it bothered me that all these families who I knew needed it were discouraged, and I don't know if they went out and got it done somewhere, or if they just sort of let it slip, and now it's 6-9 months later and they still don't have it done. They're still at risk. Their family's still not protected. So anyway, last year we built 2 new services that our firm offers. And so we've got something all the way as simple as a do-it-yourself kit. That's $347, and that's our Complete Family Living Trust Master Class Kit. It is phenomenal. You get 8 training modules, and I've counseled thousands of families through these conversations. What I forced myself to figure out last year was, what are the key decision-making points that determine whether or not a family is successful in setting up their trust or not. And I was able to boil it down into those 8 key modules. And so I created the training videos so that you now have those 8 modules to learn from. Completely self-consume on your own time, however you want it, whenever you want to do it. And then in that masterclass kit, you get additional written resources from me if you're a reader. So I've got a lot of these things in writing. And then I've got the actual legal templates for you in the kit. You download them, you fill them out, you print them. I teach you how to sign the witnessing and notary and everything. I mean, it's all in that kit. $347. If you want a $50 promo code, then you just email us, radio@keystonelawfirm.com, or send a text to 480-750-7788 and just say you want info on the masterclass. You want the promo code. Bam. You'll get that. Then we also created a little more joint effort type plan where you have to still do a lot of the heavy lifting, but you let us draft it all for you and conduct the signing ceremony. And that price point's right around $1,500. So awesome plan. You still get a giant package of value. And so we now do, even though we're a high-end boutique estate planning firm, we've now got this whole range of prices available. And so I hope that's helpful for you to kind of see the context of answering that question, all right? That kind of gets us to the end of the show. So just to recap, if you want today's trust funding instructions, you go to the website, radio.keystonelawfirm.com. If you want the masterclass kit, just shoot us an email, radio@keystonelawfirm.com, or send us a text, 480-750-7788. And if you just want help, then you can just call that number and let's schedule a free appointment, and I'll walk you through those options, 480-750-7788. All right, everyone, go out there and let's start creating that new legacy.